So welcome everyone. My name is David Sykes. I'm an attorney in Iowa and my offices are here in Fairfield. I'd like to welcome you to a lecture that I've coined a term, legal estate planning or comprehensive legal estate planning. By way of a few announcements, I'd like to thank the Fairfield Public Library and in particular the head librarian, Rebecca Johnson, for understanding the importance of this topic. And we've worked together over the last month or so. And Rebecca has gone through the library's list of books to increase the books that are available on this topic so people can educate themselves after this lecture. And I think it's great because what we're going to talk about today is a very significant paradigm change in the way the legal system works in terms of legal estate planning. I'd also like to point out that there's an article that I've written for all of you that's on that back chair. And please take a copy, or if a friend missed the lecture, feel free to take a couple extra copies. I would also point out that on my website that's identified on the letterhead, I have recently completed a 12-minute video that summarizes in a very succinct way this lecture. This will get into a lot more detail. So if friends missed it, or if you'd like to go back and just see an overview in the comfort of your home, it's on the home page. And this article that I've given you today is also available. You can print it out for friends if you like. Now, for purposes of acknowledging FPAC's presence here today, I want to thank you for filming the lecture, and I know that it will get a wider attendance because of what you're doing. I would tell you that I started this lecture series last spring, and I did my first lecture at Revelations, and I thought maybe 20 people would come, and 175 people showed up. The room only held 75 people, so we had to turn away like about 100 people, which was very disappointing to them and to me. But as a result, we quickly passed around a piece of paper and got email addresses and phone numbers, and we set up another lecture 2 weeks later, and that kicked this off. And since that time, this is my 5th lecture, and I will probably continue doing this as long as people attend. I think probably the winter weather and the ice has impacted us a little bit today, but nonetheless, this will probably be my best lecture, because I've worked on this. Rebecca inspired me. So we're going to talk about legal estate planning, why it's so important, and what some of the really common misunderstandings are with the public. I would say to you that what's happening now with wills and trusts and the paradigm change that's happening within the legal profession and the community is very significant. Now, I can see this is a pretty intelligent crowd, so when I use the term paradigm change, what am I talking about? It's a shift. Now, a dramatic paradigm change was go back to the 1800s, and people were used to riding horses and carriages, and all of a sudden the car came out. And everybody said, it'll never last. You know, we've been riding horses for hundreds of years. This is just a fad. And of course, we see where that has led. But the point is, think about the time when that transition was in play. And put yourself in the mindset of people that had this background of horses for generations, and this new fandangled contraption showed up. They questioned it for a long time. Now, it's a dramatic example, admittedly. But in the legal profession, for hundreds and hundreds of years, the concept of a will has been sacrosanct. Everybody knows about wills. You see it on TV, movies. There's all kinds of books and stories about the wills. And up until, I would say, let's say give or take 10 years ago, trusts for the average family, the average person, would mean, if they heard the term trust, they would think complex, no way for me, and it's only for rich people. That's pretty much the common understanding. And so wealthy families for a very long time have utilized trust to pass their estate assets to their loved ones, their children, their family members, in order to bypass probate. Now, probate, for those of you that may not be familiar, if somebody passes away right now, whether they have a will or they do not have a will, their entire estate must go into probate court, where it's complex enough where your loved ones will have to hire an attorney. I don't recommend trying to do probate by yourself. It's expensive, it's stressful, it's archaic. And imagine a family that's lost a loved one, and they're in the process of mourning and dealing with all of that, when they find out that, by the way, in order to access your loved one's assets, you're going to have to go through a 6 to 12 month probate court process, which is public. You have to hire a lawyer. It's going to cost you, the lawyer will charge 2.2% of the gross value of the person's estate, whether it's liquid or illiquid. So let's assume the person owned a home, a car, had some savings, had some investments. The court grosses up that entire amount that the lawyer will present to the court, and based on that, approximately 2.2%, or $2,200 per 100,000. Now, I don't mean 100,000 in cash. I mean 100,000 all assets taken together. So as you add, and when you look at the size of your portfolio, you can see this can get fairly expensive. If a person has $1 million portfolio, you're looking at over $22,000 in initial fees, plus there's a filing fee to go to probate court, and then you have to notify creditors at some point. You have to pay for newspapers. And the larger estates, and when I say larger, I mean some few hundreds of thousands of dollars, it's not uncommon that a lawyer would present to the court a request for additional fees called extraordinary fees, where the process may have brought some issues up that were not typical, and the lawyer asked for even more money. All of this descending on a family at probably one of the most vulnerable times of their life. So what we're talking about here is a paradigm shift, so that a will combined with a very simple trust, with all the complexity taken out of it, can now be done in a very practical way, a very inexpensive way, planning what you'd like to do when you're in a good time, in a good space, hopefully, not waiting till a very late stage, and avoiding probate court 100%. No probate court, no judge, no lawyers, no fees. It's almost like a miracle. How can that possibly be? Well, trust me, we're going to talk about it today. This lecture will go probably about 45 minutes. I'm going to go through all of my points, and then we'll take questions and answers. So if you have questions, feel free to write them down or remember them. So this is the big mission statement. I started doing this because of essentially the stories I'm about to tell you. I was doing estate legal work for some years, but a few situations happened that pushed me into doing more, which is why I'm here today. I'm going to tell you about 4 stories, briefly. 2 that are heartbreaking, and 2 that I think have some grace associated with it. And these are all true stories that I was involved with, so it's not from a magazine. The 2 heartbreaking stories involved, let's just say, friends of mine, people that I know. One individual had a will, and one individual had no will. And these were not 99-year-old people. These were young, vibrant friends, adults with families. And unexpectedly, they passed. Now, in the first case, the individual that had no will is still, their estate is required to go to probate, even though there's no will. And what happens in this situation is, where there is no will, the state brings in a state statute that creates a statutory will. In other words, as opposed to having nothing, no direction, they bring in a statute that tells the probate court who gets what, which may or may not reflect the wishes of the deceased. It may not have been his or her wish to have it go this way, but it brings some order to the process. It's a lot better than nothing. But this person waited and waited, and the unexpected happened. And in this case, there was a family, and the family called me after the loved one had passed and asked me, can I help? The answer is no. I mean, yeah, could I do the probate for them? Yeah, I could. But could I avoid the probate? Could I fix this? No, not really. They're going to have to go through this process. And it will work. I mean, I want to be clear. I mean, the court process is designed to help people. This is a process that's been going on for hundreds of years. And, it will create a finalization. You will get through it. But do you have to do it? No. The second situation involved another person that I knew who had a will and had visited an attorney in town here, let's say 15, 20 years ago, did a will. It's a good will. And it laid out who he wanted to receive what, protecting his wife, his children. It was very clear. And as far as that family knew, and this individual knew, if he passed, it would just all be distributed to his family, just as he had laid it out. Well, the family, in the middle of the funeral process, was trying to access some of the husband's assets, which is another whole story about husbands and wives having assets in their same name, or if they're separate or whatever. But they wanted to access some of the assets and quickly found out that they could not. They could not access the husband's assets sufficiently to cover expenses, costs. There's a process that goes on with insurance, and months of waiting can go on. And they're like, that's when they call me. And I have to tell them what I'm telling you, that sadly, the will still requires you to go to probate court. And they're like numb. And they're hardly hearing me because they're so grieved. And it took 6 to 12 months for that estate to finally go through the probate process and come out on the other end where the will was honored, but the process that it put these folks through was very stressful. And I might add, a lot more expensive than what I'm going to be telling you about today, this paradigm change. Now, the 2 good stories, well, not good stories, the stories that had some grace. I did estate planning for 2 families years ago, and the husbands, who were the ones that passed, were very vibrant guys, athletic, One was a former football player, good health, strong as an ox, and one day he was gone. It didn't happen the way one would expect. It happened suddenly. And it's similar with this other individual. And the families came to me and called me, and I said, I know how difficult a time this is, and I can't begin to take away or help you through this difficult time, I understand. But the one positive issue here is we did all the estate planning. There will be no probate. When the couple had come to me years before, we had sat down and gone through all of their assets, all of their plannings for each other. What if the husband went first, the wife went first? What about the kids? What about grandkids? The whole picture. We created it in their comprehensive estate package, which primarily means the trust. And so when these gentlemen passed, the estates passed automatically by law the second they passed. It was all done. The wife could access all the assets. Everything was planned. Not that it relieved the grief, but at least the financial circumstances and all of that for her, for the wives and the kids, had already been taken care of. So that's what we're talking about here. Is it a pleasant subject? No. I mean, most people will avoid this conversation until it's the last breath. And they go, I better probably do something. It's very common. I mean, who wants to talk about their mortality? However, a lot of us sitting here today that may be married had to face that same question if we took out an insurance policy, if we set up a retirement account. We take responsibilities for our loved ones as part of being an adult. Is it the greatest conversation in the world? No, it is. It's a big deal. But this is designed to avoid the stories I told you. So in a nutshell, that's what this is about. Now, let's talk about wills for a minute. Wills, as I said earlier, are as old as the hills. Everybody knows about a will. And the common understanding right now is by the public, by the legal profession, by most authorities, a will is the way a person passes their estate to their loved ones. So what's the difference between an older will and, let's say, my wills? Good question. The older wills, which you've seen on Perry Mason and all kinds of movies and books, the older will says, I, Jim Jones of sound mind and body, appoint as my executor my wife or my brother, and upon my passing, all of my assets shall be distributed as follows. And in the will, it'll say, my house and all my money goes to my wife. And when she passes, it all goes equally to my kids. And if the kids somehow predecease me, God forbid, it will go to their children if they have any. If they don't, then it goes to my other surviving children, or something like that. Everybody's got a different story. But essentially, the will chooses the executor and passes the assets right in the body of the will, which we now know will go to probate, right? Anybody think that's okay? You're all with me? Okay. So that's the old will. Now, as recently as 10 years ago, lawyers that are friends of mine and doing the best that they know how, wrote hundreds of wills for people in the community doing the right thing. And in many cases, telling these people, look, now that you have this will that's signed and notarized and it's all legal and official, to keep it safe, I think you should go down to the courthouse and put it on file, so that if anything happens, this copy will be safe. However, what do we now know? That's a direct, fast track to probate. right? So people now come into my office and they look at me and I tell them, we're going to have to get that will and tear it up. And they look at me and they go, what? What do you, no, I paid $400 for that will and this is a good lawyer. And I go, yes, true, but times are changing. You can put the horse in the barn and we're going to put you in a car. So my wills, what do they say? It's very simple. It's a simple difference, but it's all the difference in the world. My will says, I'm John Jones, and I do appoint an executor. And at the time of the creation of this will, I simultaneously create my revocable trust and have all of my valuable assets put into this trust. Signed, notarized, witnessed, Jim Jones. So the first will creates the probate track. The second will acknowledges the existence of the trust, and rather than attempting to distribute the assets through the will, says all the assets at the time this will was created, which could be years ago, are going into the trust, my trust, that I control at the same time I create the will. So what you have here is a double protection. The will is supporting the creation of the trust, and the trust, being done properly, stands on its own two legal feet. So the question is, what just happened? Let me pick out an unlikely soul. I'm going to pick out you, sir. So let's say we're talking about you. I'm going to explain to you what a legal fiction means. A legal fiction, kind of a make-believe, not make-believe. It's acceptable in law, but nothing really changes. So right now, let's just say, everything you own, is this your wife?
Yes.
Everything you own together, as individuals. Would you question that? It's yours. What can you do with this? Anything you want. It's legal. So I'm going to create a document right over here that says this is your trust. And everything that you own is going into this trust. But you're the creators of the trust. You're the trustees of the trust. And you have 100% control of those assets, just the way you do right now. Which means same tax return. You don't have to get a tax ID number for this new trust. You don't have to do anything differently, with some minor exceptions, than what you're doing right now. It's a piece of paper. But, God forbid you passed, everything's in the trust, and there's no probate. The survivor gets everything by force of law, no questions asked. That's what I'm talking about. So, God forbid that.
Have to be put into the courthouse as a record?
No court contact whatsoever. It's not their business anymore. You don't own anything individually. Probate is designed to pass an individual's assets to their beneficiaries. As an individual, you don't have any assets. Your trust has the assets. Now let me give you an example of this, which I think you can follow easily. I could say to you, what is the ultimate goal of the probate proceeding? Anybody want to make a guess? Didn't think so. The ultimate goal of the probate proceeding is to get a piece of paper that the judge signs and file stamps it and says, this probate proceeding has been legally done, I approve it, and it's now concluded. It's a court order, which then goes to the executor, and the executor uses that as the key to sell the real estate, to sell the car, to access the bank accounts, to access the investment accounts, because these institutions cannot give those assets over without this piece of paper, or they would be liable. They have no legal authority to give those assets to the loved ones without the force of law giving them this comfort. Okay? Does that make sense? Now, if this is your trust, if we do this trust correctly, and with all the proper legal terms and so forth, this trust has the same legal value and power that the judge's probate order has. They have equal legal status. Wow, who knew that? And the trust, as I'm going to tell you in a little while, is going to cost you less than just doing it the old way with the will. Avoid all the stress, protect your family, and avoid the whole issue of probate. Can you believe that? I mean, is that startling? But this, for the last 10 years, is what forms the basis of what I call comprehensive legal planning. It's like the guy who owned the horse getting in that car the first time. You can imagine how they felt. Wow, this is a whole new deal. Obviously, that's an exaggerated example, but I'm just trying to put you in this mindset. We are shattering the legal paradigm that's existed in this country for hundreds of years. Now, we're not shattering it for wealthy people. Somehow they just always find out. Why? Because they have so much money, and the accountants and the lawyers, they're just part of their life. But for the average folks, people that have, a decent estate, even in some cases a fairly large estate, they don't know this. I had a friend come up to me in the last 6 months. It's a true story, no names, of course. This gentleman is worth many millions of dollars, has a wife, has children, very smart, very successful business guy, well respected, and we're talking in a social situation, and he confides in me he's never done a will. I mean, he's almost 70. And I look at him and I'm thinking to him, this guy is so smart. He's started more than 3 or 4 major businesses, been very successful, highly regarded. And I look at him and I go, what do you think? You're still a hippie in your 20s? If something happened to you, I tried to stay calm. I tried. Do you have any idea what would happen to your wife and your kids? The whole thing, all these millions of dollars would go to probate with no will. A state statute would tell your family who gets what after a whole life's worth of work. And he looked at me and he went, you're kidding. I went, no, I'm not kidding. I'm going to come in and see you. I said, well, please do. Never heard from him. Who wants to deal with this stuff? It's not like going to a good, fun movie with popcorn. This is a serious conversation. So that's why I'm here, and that's what I'm trying to communicate to you. The will can be used in a way that supports this new paradigm, that supports the trust, and with simple language, we avoid the pitfalls of the will, the probate, the stress to the family, the expense to the family, and it's all fairly easily done. It's not magically done. It takes a little time, but it's not hard. It's less pain than going to the dentist. Now, I want to talk to you about the wills, and the same concept will be true of the trusts. Why is it that sometimes less is more? Well, it's a provocative statement. The old wills that chose the executor, just like we heard on Perry Mason, and said, attached to this will is a list of all of my assets. I mean, very particular, every item listed, the account number, what it is, where it is, just That is what my executor is to distribute. What's the problem with that? Well, I could ask you the question, but I suppose none of you are going to get the answer right.
It's frozen. I mean, it's frozen in time.
Correct. It's frozen in time. At the moment that will was executed, that exhibit was correct. It listed all the assets as of that time. So let's move forward 10 years. Well, just the way the world works, some assets were sold, some are new. That exhibit is no longer in play. It's no longer accurate. So to be accurate, our person here needs to come into his lawyer every 2 or 3 years and add an amendment or redo the will to reflect the current status of their assets, which can get a little complicated because we're trying to do more. We're trying to be so specific. Now, the other concept of this modern comprehensive planning is we don't do that. I don't do that. I don't create the exhibit of everything. In the trust and in the will, I simply say, all of your valuable assets are now in your trust, including but not limited to cash, real estate, investments, retirement accounts, insurance, vehicles, collections, art collections, whatever else we feel we should say. Is that enough? Well, guess what? It is. All valuable assets. Now, when we get into the trust in a minute or two, there are a few exceptions where we have to do a little bit more. But for most assets, just the generic mentioning that all of your assets are now in your trust is sufficient to bypass probate and sufficient for your trustee, not the executor. The executor is for the will, right? Keeping apples and oranges separate. But in the trust, it's a trustee. And if you're both gone, the legal term is your successor trustee. Your successor trustee with that trust has the authority to just take all your assets and give them away exactly how you listed in the trust without having to have a massive exhibit. You could talk to your successor trustees and give them exhibits, but we don't have to make it part of the trust. We don't have to complicate the document. Do you see what we've now done? How we've moved from this will or no will and probate to a modern trust where we're not even itemizing everything you know, so you have to keep being tied to changing it. Now, what happens, I'm going to jump ahead, in a trust, this is a brain teaser. Let's assume you did a trust and did an exhibit of all of your assets, exhausting everything. 10 years go by, God forbid the person passes, and somebody's looking at the trust and seeing that there are some new assets that were not included in this very exhaustive list. What presumption may arise? Well, depending on how your relatives get along and how feisty everybody is, they could say, well, you know what? Doggone it. If he didn't put it in the trust, he must have wanted it to go to probate. After all this. Could that happen? Yes. And has it happened? Yes. So what we have to do in this comprehensive package that I'm describing, we have to make sure there are no back doors left open. So more is not always best, because more, if we don't keep it more, and we later, it changes, we've kind of put ourselves in a box that we don't have to do. Now, does that mean that your wife would not know where everything is, and your successor trustee, let's say it's your son, where they know where everything is? Of course they should. But does it need to be in the trust? Not necessarily. They just need the ticket that what they do is legal without probate. That's all they need. Okay. So the trust, as we've rolled into it, works in tandem with the will by doing less in terms of identifying the assets. We avoid this complexity issue of a challenge. it's really fantastic. Now, what are the terms associated with the trust? Again, remember, lawyers do this. So lawyers have to make everything sound complicated so that you feel you need them. So these are just words, remember that. So the basics of a trust, well, the term trust, if it's your trust and your trust, you are both the settlor, parentheses, creator, grantor, it's your trust. But the legal term they use is called settlor. I always say, remember the pioneers settling the West. They're settling the West and claiming their lands, and they're settling the territory. You'll never forget it. So you're the settlor, and you're the trustees while you're alive. That's the terminology. Successor trustees would be who you appoint to distribute everything if you're not there. Successor trustee. And finally, the word beneficiary, who you're giving the money to. That's the lingo. The more versus less is a striking and a very important point. Now, this is a little advanced, and I don't see anybody falling asleep, so I'm going to go this extra step. In the will and in the trust, we've already established that what we do is we simply say it includes all valuable assets, and we give a paragraph of examples, including but not limited to all of the things I've already mentioned. Okay, so once the trust is done, let's assume you're in my office, we've executed all the documents, we've done that whole thing. Okay, and you're finished, you're done, you're graduating. I whip out another memo and I say, okay, now let's do one more step. I don't do this in the first part because I don't want to overwhelm you. I'm already getting you to make life important decisions. So how much do I want to hit you with in the first, go around? As little as I can. So we now have your trust. We have your will, we have your trust, you're ready to go. And we've generically mentioned all these valuable assets. There are 5 types of assets that require another step. That other step, as we'll see on 4 of them, well, on 3 of them, you have to change the name of the asset to the trust once you have the trust. So let's be specific. What am I talking about? Well, the first one is bank account. I'm going to pick on you guys. So right now, do you have a checking account that is in both names? Okay, and it's in your name and your name, right? Well, let's assume we just finished your trust. You're going to call your bank, say, hey, I just did my legal estate planning with this really handsome, really lovely lawyer. That got a smile. Huh? And modest too, right. And he told me to come in here and to get a form and change our checking account into our name as a revocable trust. And the bank's going to say, okay, I'll give you a form to fill out, and we need a copy of the trust. So, no cost. Your checks will get reprinted that simply say your name and your name revocable trust. That asset is now generically mentioned in your trust, right? We said checking accounts or bank accounts, but we've changed the name. We've closed the gate on any potential probate issue. The second category is investments. Let's assume you have Edward Jones investment account with however much money, $1,000 or $1 million, same thing. You call them up, tell them the same story you told the bank, you fill out a form, you give them a copy of the trust, and they change the account into the name of the trust. Does it have any tax implications? No. Does it have any change in your day-to-day activity? Absolutely not. Nothing. It's just a name. Is it awkward? Well, yeah. What do you mean, trust account? Well, yeah. Where's the horse? I'm not comfortable in this car. I feel more comfortable riding my horse. It's because you're used to it, but you'll get used to it. I had to change my checking account into my name, the David E. Sykes Revocable Trust Account. Well, it was a little, okay, I just did it. Same thing I'm telling you to do. It avoids the probate issue. So we have these two categories, checking account, investment accounts. Third category of these special assets, real estate. It's very important that we change the name of the deed on your home instead of, do you own a home? Do you own a home, ma'am? Do you have a deed? Probably in both names. So we have a process that we do where the deed is changed to both of your names in the trust. The trust owns the house. Well, who owns the trust? You do. Who controls the trust? You do. Is there any practical difference? Only one. We avoid probate. That's it. There is no other secret agenda. So that's the three assets that we need to change. The fourth asset is businesses. Now, in the generic listing in the trust where I said businesses, is one of the assets, cash, gold, whatever, businesses, I generically mentioned business. But if you own an active business that's bringing in some, decent money, I will create an exhibit to your trust that in one short paragraph describes the business, gives the name of the business, what it does, where it operates, what your stock ownership is, whatever. That descriptive paragraph added as an exhibit to the trust is sufficient legally to put that business under the protection of the trust. Do you still own the business? Yeah. Do you have to change the name of the business? No. Do you have to change the name of the checking account or savings account for the business? No. Does anything change practically? No. But if, God forbid, you passed away, absolutely that business is part of the trust. No way, no how can it be challenged. That's 4 categories. Is that right? Fifth category, which is basically a protected category, it's insurance and retirement accounts. How many people here have life insurance? Okay. I'm going to pick on you. When you took out the insurance, do you remember having to fill out what they call a beneficiary statement? In other words, if you, God forbid, passed, who gets the money? That is honored, and the probate courts have never inquired into that. Insurance policies have the golden cow protection. The insurance policy controls, you pass, the loved one gets the money, end of story. Now, did I mention insurance generically in the trust? Yeah, I did. Extra coverage. But the insurance will pass directly to your beneficiary. A retirement account, same treatment. How many have retirement accounts? 401k, IRA, right? Do you all remember filling out a beneficiary form? That controls. So if you passed away and all you had was that retirement account, you're probate proof. No, you probably didn't know that, but that's true. Does that mean we shouldn't put it down in the generic listing? No, I put down insurance, retirement accounts, just to make it clear that that's one of your valuable assets. But when we change the name of these other assets, they're protected, and with insurance and retirement accounts, they have what I call a golden protection. Sidebar, should we name as our beneficiary for your insurance or retirement account, should we name the trust as the beneficiary? How many think we should? How many think we shouldn't?
I'm not saying as a beneficiary, but just make it a part of the trust along with all other assets.
Well, we're doing that. But what I'm saying is, if you passed away, or if this hypothetical person passed away, should they go to their retirement account company and say, look, instead of leaving this to my daughter directly, I want to list my trust as the beneficiary of my retirement account. The answer is no. Why? Because when this retirement account passes to your daughter, it's creditor proof. That money goes to your daughter regardless of any debts that you may have. If we name the trust as the beneficiary, the trust is still subject to creditors. So what the trust is not is a way to avoid taxes or a way to avoid creditors. That's different planning. Can I help you in those areas? Probably, but that's not the topic of this discussion. We're talking about avoiding the probate, the archaic probate process. So the insurance and the retirement accounts leave the beneficiary statements alone unless you want to change the beneficiary for reasons of your own. Okay?
Can you repeat, you said that the trust is subject to creditors? But not taxes?
No, it's subject to taxes.
Can you repeat that whole,
Yeah.
what the trust does protect and what it doesn't protect?
Okay. The trust is designed to pass your estate to your loved ones by avoiding probate.
Probate and taxes.
No, didn't say taxes.
Inheritance taxes.
I'm going to get to that, but don't.
Okay, so yeah, there's a lot of different little things of which, none of which I understand, so just continue and.
Okay. The trust is designed to bypass probate and that archaic process and subject your family and your loved ones to all that entails. And I don't say this as any disrespect to the probate process. If you understand what I've just said, and you want to still have a will, knowing that it's all going to go to probate, and that's okay with you because mom and dad and grandpa did it, so be it. That's your decision as an adult. But I want you to have all the facts. Now, knowing what I'm telling you and knowing the downfalls of probate and the alternatives is my job today. So that you understand that, and then you make the best informed decision that you can. My recommendation, do the trust. It's going to be a whole lot better. But do you have to? No. But just be informed. That's what I'm doing. That's what Rebecca and the library's doing. That's what these books are doing. They're designed to educate you so that you understand the field, the area. What are you getting into? All right.
I have a question about probate. Do you have to have an attorney? Can you represent, can someone represent the family or whatever as a...
Technically, practically, yes. Is it a...
Yes, you have to have an attorney?
No, you can do it yourself. Is it advisable? In my experience, it's not advisable. There are a lot of forms, there's a lot of procedures, court protocols, there's a whole step of things you have to check off. You'd have to get all of that information and go into the court and tell the judge you're here to do this as a layperson and hope that they'll help you walk through it. Can you do it? Have people done it? Yes.
Okay,
I have a question.
Yes.
So how long does it take for a will to probate in Jefferson? Is it county or is it the city?
It's the Jefferson County District Court. It's the county where the person resides. And generally speaking, there's always exceptions, I say 6 to 12 months, give or take. Okay.
Quick question.
Yes.
I'm from Pennsylvania, and my understanding there is that if your estate is less than $10,000, they don't do probate. Is it different here in Iowa?
Yes. Every state controls the probate process. Some states have created expedited probate for smaller estates, made it easier, etc. Here in Iowa, generally you go to probate. Are there some efficiencies that the court may allow potentially? But by and large, probate is probate. The fees are the fees. The time frame of 6 to 12 months is typical. Are there exceptions? Yes, I think there are, but not in the cases I've dealt with. Okay. I want to save any more questions toward the end. Now Jason, Are the questions being picked up by the mics?
They're being picked up by the mics, but not the other camera.
Okay, that's fine. I want to move on and wrap it up, and then we can have questions and answers. So we've covered the will and the trust. What other documents are recommended in this comprehensive package? Well, one important document is the medical power of attorney and the living will. And let me give you what I call the good news and the challenging news. The medical power of attorney is basically a document that says, I'm going to pick on somebody else. I'm going to pick on this young lady here. Let's assume circumstance comes up where you have to have a relatively simple surgery, where you're going to be under anesthesia for a short period of time, but you're not going to be able to speak for yourself during those hours. So the medical power of attorney allows you in advance to have a form that says, while I'm under anesthesia or while I'm not available, this medical advocate speaks for me. They're legally approved by you that they can represent you and protect you and deal with the doctors while you're temporarily unavailable. That's what this document does. That's the good news. The challenging news is the living will. And these documents are done together. A living will is a much more serious situation, as you probably, most of you know. That would entail a situation where a person is essentially at an end of days circumstance in the hospital, hooked up to machines that keep them alive. If the machines were turned off, they would not survive. And the doctors are saying, there's no way this person's going to ever be the same. Without the machines, they will never become themselves again. And the question is, ahead of time, that person could fill out a living will that says, if I find myself in that situation, do you want to be kept hooked up to these life-saving machines, or do you want to be taken off the machines and let pass? The default language says, take me off. But you could ask to stay on. It's a very personal decision, and part of this process, I help my clients talk through this, see what they're thinking, make sure they understand it. It's a significant decision. And so a little hand-holding is not a bad thing. So that's what those documents are. What are some other documents that could come up? Have you ever heard
Can they be the same, the medical power of attorney and the living will?
It's essentially one document. And there's standardized forms that the Bar Association, hospitals have all come to agreement on. I have them, and what my job is, I put in your information after you and I talk. In other words, even though it's a standard form, there are a half a dozen important issues to discuss based on what you want. It's not just fill it out and there are issues depending on your circumstances. But it's not a terribly difficult document to draft. What are some other documents before we conclude? Have any of you ever heard about the durable power of attorney? I've had folks come in when we're doing the comprehensive estate planning. I remember one family, lovely husband and wife, 2 adult kids. We finished the process, and the husband says to me, David, I want you to create 2 durable powers of attorney for my wife and I, so that if we become unable to take care of ourselves, but we're still alive, I want my son, and if he's not available, my daughter, to step in our shoes and take care of us. Okay? And he said, my dad did that. And so, is that included in the price that you quoted me? I go, if it's necessary, yeah, there's no additional cost for that. Well, he says, well, I want one. I said, are you sure? He says, absolutely. I said, well, let's talk about it. Let me tell you 2 stories. He says, okay, and he's adamant, by the way. And I said, if you want it at the end of this conversation, I'll give it to you, no problem. Here's the deal, I said. If, God forbid, 5 years from now, you and your son are estranged, You and your wife go to vacation in Tahiti. Do you realize that this document, your son could sell every asset you own, could empty your bank account, sell your house, sell your business, abscond with every penny you've ever owned? Will that happen? Probably not. But do you understand that? He said, you're kidding. I said, I'm not kidding. A durable power of attorney, while you're alive, gives the holder of that document the same legal authority that you have over your estate. So if you were unavailable or having a bad month and your son went to Vegas and lost a lot of money, they could wipe you out. Is it going to happen? Probably not. But do you want to do that now when you're healthy? I said to this gentleman, I said, look, if in 5 or 10 or years from now you see that this situation is developing, it takes me 1 day to do these documents. You don't have to have them laying around for 20 years. He said, don't do it. He said, please don't do it. Misconception. Now, second story. A couple comes into my office. The daughter is 65. She comes in with her mother, who's 90. Mom has been living with the daughter for 5 years. Mom is now getting to a point where it's difficult for her to write checks and do this and do that. And the daughter's been helping her for 5 years. And mom comes in and says, David, I want my daughter to have this durable power of attorney because I just can't do it anymore. So what do? I satisfy myself that this is a legitimate situation. The daughter is taking care of mom. There's no funny business. This is a real important matter for the mom to be able to count on the daughter. And I'm not worried about the daughter taking off and leaving mom hanging. I'll execute the durable power of attorney in the name of the daughter because of the facts of the moment that tell me, to the best of my ability, this is a good situation where mom's interests will be served. But it's not an automatic. Signing documents like that have serious legal implications. Okay. So how this all comes together. How it comes together is, at this stage of your life, for anyone, I would say, that has assets over $50,000, has a family, has insurance, life insurance, is concerned what would happen to their family if, God forbid, something happened to them, this should be considered. It should not be considered when you're 85 for the first time. In the article that I gave you, that I hope if you didn't get one, that they're on the chair, on the back page, I've given you a chart that shows you how the fee structures go. And I'm happy to tell you that, and I believe I'm the only attorney that I know of that does this, I discount my standard legal fees based on the size of your estate. My normal estate planning fees for a estate of, let's say, $2 million or more, it's about $2,500, give or take. If you have an estate that's worth, let's say, under $500,000, my fee for you is $750 for the same exact work. Now, if you're married, I would add $250 for the husband or wife, so it would be $1,000, but I would do both of you as a couple, which makes it very affordable when you think about the cost of probate at 2.2% per 100,000. That's $2,200 right out of the gate, plus all the other costs. A person with $400,000 is a pretty good chunk of money. And that, if you're single, it's $750 for all the legal work, the consultations. I build in this mini seminar so that you're educated and you understand how to protect yourself. And that's my commitment to the community, to avoid those stories I told you at the very beginning. I was pushed to a point where I said, this is not going to happen if I can help it. And respectfully, I didn't hear any other lawyers, accountants, insurance folks, estate planner. I didn't hear anybody talking about this. And I talked to a lot of them, and they just didn't feel it was their responsibility. And as I stand here right now, there are many lawyers in town that are good lawyers, that if you walk into their office and ask for a will, you'll get a will. And the word trust may never be mentioned. It might, but it might not. And that's not acceptable to me. This is a specialty area of law. This is what I've chosen to specialize in. I want people educated and protected. Once you know this, then you make the best decision for yourself, from an educated point of view. I've also found, I've done about 100 families, give or take, over the last 5 years, 100 estates, which on the one hand sounds like a lot. But on the other hand, I've barely scratched the surface in terms of a community of 10 to 12,000 people. Many have wills out there that are at the courthouse. Many have never done wills, that they're like little ticking bombs, that at some point they're going to go off on somebody, a wife, a child, somebody that can be avoided. And with what I'm doing and some of these books and knowledge that the library is offering, this is an attempt to help educate people into this new paradigm. So what I'm talking to you about is fairly common knowledge. This is something that's available. Should I do it or not? That's your decision as an adult. But at least know that this is real. And that if you hear anything to the contrary, you're hearing about the person that still owns the horse, that doesn't own a car, if you follow my analogy. Okay. At this point, I'm going to conclude the lecture portion of the presentation. These books are available. The lecture should be online, YouTube or FPAC. If you go to my website, there is, as I said, a 12-minute video that summarizes this lecture. Plus, you can print out copies of this article for those that may have not attended. Thank you so much.